be decriminalized in South Africa will only be heard next year in May. The sex workers brought their case to the Western Cape Province's High Court themselves 2 days ago, challenging the constitutional validity of certain sections of the Sexual Offences Act and City of Cape Town bylaws. Sex work is currently a criminal offence in South Africa. Social justice organisation Section 27 is representing HIV/AIDS activist organisation Treatment Action Campaign and non-governmental organisation Sonke Gender Justice in the case. To talk to us further on this, we're joined on the line by health attorney at Section 27, Khuselwa Dyantyi. Khuselwa, thank you for joining us. How are you this morning?
Good morning, Asanda. Thank you for inviting Section 27.
It's our pleasure. Let's start then in terms of what about the constitutional validity of the Sexual Offences Act that sex workers are challenging?
So in South Africa, we all know that sex work is criminalized. So Sexual Offences Act, certain sections of Sexual Offences Act criminalizes the sale and purchase of sex between consenting adults. And sex workers in 2024, in May, they have approached the High Court in the Western Cape to have these certain sections of Sexual Offences Act repealed, only because it criminalizes their work.
So talk to us then in terms of the reality of sex workers in the country. In what do they remain vulnerable, and what are the challenges they face?
Because of their work, it has put them in such a vulnerable position. For instance, they are now exposed to exploitation. They are exposed to even trying to report certain acts of violence against them is difficult because of the work that they do. It is illegal. And in terms of our intervention as Section 27 and Treatment Action Campaign, as well as Sonke Gender Justice, which we advocate mostly for the rights of women, either in accessing healthcare services in our country. Sex workers themselves, they have challenges in trying to exercise these rights, in trying to access healthcare services because of the criminality of the work that they do. So what Section 27 or the organizations that were representing sex workers themselves, they have put these concerns in their papers on what criminalization of sex workers has, the impact it has on their rights. For example, their right to access to healthcare services, their right to freedom from violence at all. So we came in to support mostly, I think, that part of their case. And there are many organizations that also came in the case to support decriminalization of sex work, only because it violates so many constitutional rights of sex workers and the rights of these sex workers, mostly Black women, transgender women, or women from the LGBTQI community.
So let's unpack then what transpired during the court proceedings 2 days ago.
So 2 days ago, when the matter, it was in fact Monday and Tuesday, when the matter was heard on those 2 days, it's not, we were not arguing on the merits of the case, but the parties that were before court on those 2 days, they have applied to be admitted so that they can submit arguments in the main application, which will be heard next year. So, on 1st and 2nd September, these organizations or these parties, there were about 21 parties that have appeared before court to say why they are interested in the case. Some are interested because of, I would say, the constitutional validity of this section. Some they came to say that criminalization of sex work is necessary in South Africa. So not everyone that joined the proceedings on the 1st and 2nd of September are in support of decriminalization of sex work. However, the majority of the parties, they have indicated to court that they want to show or they want to assist the court when they come to the final decision in 2026 on why decriminalization is necessary. So they will bring evidence to assist the court in making findings on decriminalizing sex work. So now, on the 2nd of September, everyone that have returned to the High Court or who have filed their application to be admitted as friends of court have been admitted, and we are given opportunity to submit evidence that supports our positions. Everyone has stated, say why they want to come in. So we are now we have given timeframes on how we can file that evidence, which is heads of arguments in terms of court. We are not going to be filing affidavits, but there are parties that will file a certain supporting evidence. But most of us, we are required to file our submissions in terms of heads of argument, and the matter is being set down for hearing sometime in May 2026.
What is the reason given for that the case will only be heard next year? It's quite a time frame, a long one.
Yeah, it is a constitutional matter, Asanda. As I think I have told you, the case was actually instituted in 2024, in May 2024. So next year it will be 2 years. Because of the nature of the case, it challenges constitutional validity of certain sections of the law. It requires the court to properly, assess the evidence that has been brought by the parties. And now that there has been more parties that are interested in joining the proceedings, that means the applicants, the sex workers themselves, they must be given time to respond to some of our papers or to some of submissions that we are bringing before court. So we cannot, it's unfortunate that it will have to take this long, but it is necessary because of the evidence that is before court. Already in this interim application that was heard on the 1st and 2nd of September, the court had about more than 2,500 papers that were before it. So can you imagine now on the main application, I know the sex workers case on its own, it's complex and it had a lot of evidence. And now that there are so many parties that are coming in to add on that, it requires a court to properly consider that evidence. And I think we have requested that because of the nature of the case, it must not be heard by one judge and it must be heard before a full bench. So it requires the court to now set time to have all of those judges available so that they can sit for the hearing of the case.
Does that also then further speak to an issue that there is lack of research when it comes to these matters pertaining to sex worker rights, that it would take this long for this case to be heard? It's been described as a landmark one.
In terms, yeah, I don't know about that because, the person that has to answer the question is the state. and the state is part of the proceedings, and they are not opposing decriminalization of sex work because of the work that has already been done in this program. But the only issue now, we all know that it's a matter of passing the law. There is a bill that is ready for the parliament to pass, but it hasn't been passed. And because the state is part of the proceedings, they were also compelled to answer to the court on why that bill hasn't been passed, why they are not opposing the proceedings, or why decriminalization of sex work has not been passed in South Africa. So there
Right.
is a lot of research. I cannot say there is lack. There is a lot of research that at least supports the idea that it must be decriminalized because of the impact it has on these, especially Black poor women that do this work, and the impact it has for these sex workers in accessing certain constitutional rights that they have
Yeah,
in
well,
terms of
Khuselwa,
our law. So
I'm
there
sure you've
is
got
a
your
lot
work
of
cut out in
research.
front of you as you build up towards next year, May. Let's leave it there for today. Thanks again for your time.
Thank you so much, Asande.
All right. Khuselwa Dyantyi is Section 27's health attorney talking to us about this landmark case about the decriminalization of sex work and sex workers bringing that case forward in terms of challenging the constitutionality or the constitutional validity of that.